Hello everybody, I'm Richard Saisomorn. We are on iFreedom TV. Today we have the case of Hong. In Missouri, something is terrible to her. This case is happened last few years until recently, until now. So the case is not over, but a lot of problems just follow. We have the case of Yang, and she is the victim of injustice in the soil of America, the land of America. I would like to introduce to our public viewer that Yang is a victim. We don't expect that this case is going to happen in the soil of America, but it happened. We would like to introduce this case to the public, and we have a lot of documents, so I would like to make a short script, and it take about an hour and just a little bit, and we would like to show to the public what's going on and what happened to her. And after I heard this story, unbelievable. It shouldn't happen to her at all. Our friends, today is November 22nd, 2015. So she's at my studio at the iFreedom TV with her friend. Would like to prepare all the documents to show to you. Here is the case.
Say no, then I know you're ready. Okay.
Okay, ready.
Okay. Hello, I am Yang. I'm a Hmong widow farmer in Cassville, Missouri, who became the victim of predictor lending actions against me by Hometown Bank, Berrien County Circuit Court, Berrien County Sheriff's Office, and the Appeals Court in Southern District, Missouri. They were a conspiracy to steal my money in my bank account, seize my productive poultry farm, personal belongings, and left me and my children on the street. This case contains 4 parts as follows. The first actions by the bank involve fraud, breach of contract in both letter and intent, felony theft, unlawful acts, violations of basic fiduciary obligations, and together in conspiracy with the court violate the moral and legal rights of me as a widow farmer with bias and prejudice. Hometown Bank's actions were intentional, committed against the disadvantage of me, who trust them. The bank knew that I would not be sufficiently equipped to contend with their confusing, complicated policies or to recognize their actions as intentionally deceptive. Hometown Bank, by way of several immediate and blanket attacks launched before the buried me, I, the widow, could comprehend their intent or marshal any reasonable defense, took possession of the property and left me and my children living in the street. Second, the Berrien County Court's actions show a perversion of justice, deny justice, show obvious bias towards the bank, and prejudice against me as the widow, deny due process, equal justice, and exhibit contempt openly against me. I was denied the opportunity to present my defense at the December 13th hearing. The order was filed, stamped on December 13th, but not dated and signed until December 14th. At the hearing on the 13th, I was told by the judge that he had already made his decision. I would receive a copy for me to go home. The April 16 hearing, the court did not require a copy that Hometown Bank had to prove its legal right to foreclose my property. And for no apparent reason, the Berrien County judge had actually requested a bankruptcy filing for a completely different party having no relation whatever to be placed in my file and faxed to both attorneys, which prompted my attorney to request permission to withdraw representation. Inexplicably, when records of these hearings were requested by me, the court clerk stated that this hearing was consent judgment and the second was default judgment. Therefore, there were no records kept for either hearing, according to the clerk's letter. Other constitutional violations also occurred. The third part. This case involves the actions of the Berrien County Sheriff's and Sheriff's Department personnel. I did not receive notice of warrant hearing by reasons of the notice being sent to a wrong address, in spite of the fact that the correct address was a 2-year-old matter of record. When I missed the hearing, a warrant for arrest was issued on failure to appear. The charge against me was direct result of the Hometown Bank's breach of contract, actually making the charge unlawful on its face. Nevertheless, I was arrested, held without bond, incarcerated for a week, denied medical care, even denied a blanket. I was told by a deputy that if I gave them $2,005, I would be released. I did, and I was not bond. Hearing was held, and no explanation was given for the unorthodox manner of releasing me. The charge that was filed against me ensured Hometown Bank's breach of contract with the court's action collusion, making it part of my complaint as a whole. The fourth part involves the actions of the appeals court. In my legal brief, I took special care to explain that the deficiency in form and format of my briefs were due to circumstances beyond my control, and asked the court to examine by my pleading for facts that the state a claim and mandate remedy. I asked the court to take into consideration by my circumstance and to not dismiss my pleading unless there is absolutely no possibility that I could prove my case. But the court chose to dismiss my pleading on technicalities generally without even offering an opportunity to amend or remedy the deficiencies. The court itself, in its dismissal, stated that its actions were necessary for judicial impartiality, judicial economy, and fairness to all parties. while judicial economies might be a valid basis, impartiality and fairness were totally disapproved by the court's unwillingness to allow a method or remedy or try to level the field for the sake of justice. A court due process and to prevent further irreparable harm, this was a case of severe abuse of actions that shocked the Coke science, that put a family on the street and took by constitutional violations, injustice, illegal acts, theft, fraud, conspiracy, everything the family had, and the court's dismissal of the appeal enabled these abuses to continue, augment, and destroy. Technical follies only, no matter how severe, are not held by the Supreme Court to be sufficient alone to justify dismissal, where the purpose of the court is to uphold the Constitution and provide due process, equal justice, equal protection of the law to every person. To act against the interests of justice and averse the proceeding, to violate its oath and refuse to uphold and support the Constitution was a federal constitutional violation, placing the appeal court subject to federal authority. The summary of facts. On July 1st, 2003, my husband and I purchased the property identified as 9671 Farm Road 2230, used to commonly known as Route 5, Box 5465, Cassville, Missouri, a 47.5 acres poultry farm, which we operate successfully. The purchase price was $619,000, and the default trust with Hometown Bank for $510,000, with annual mortgage payment of $51,945.62 for 15 years. The loan contract of July 1st, 2001. On June 29, 2011, my husband died suddenly of a heart attack, leaving me, the widow with 2 children, and a poultry farm to operate. I suffered the loss of my husband with his death, assumed the heavy burden of sudden total responsibility and control of operational, financial, family, and business requirements. I continue to operate the farm successfully alone. This is the death of my husband's certificate. Exhibit number 2. On August 3rd, 2011, a little more than a month later, individuals unexpectedly appeared at the property with an agreement prepared by the bank to buy the property and take over operations. Income from the arrangement was to be divided between the bank and the buyers. I did not accept the agreement. This is the contract, exhibit number 3, contract for sale of the farm and fraud agreement. I renegotiated of the new loan contract agreement to reduce the mortgage payment from $51,945 to $42,704 per year to extend the life of the loan for 13 more years to be paid off. And the first due date started October 1, 2012, and it will be due every October until October 1st, 2024. This is the contract agreement that agreed on November 28, 2011. Without warning or notice, Hometown Bank withdrew $10,924.29 from my bank account on January 27, 2012. This is the first money stolen that Hometown Bank took. Exhibit number 5. And on March 12, Hometown Bank embezzled again for $11,099.12. And this is exhibit number 6 for the second money stolen. Subsequently, there was nothing in the loan contract on November 28, 2011. See Exhibit 4, authorizing such withdrawals. No payments were due at that time. No offset withdrawal were defensible, and no notice or explanation was given to me, either prior or subsequent to the withdrawals, causing a breach of contract. These withdrawals left me without operating funds. Exhibit number 5 and 6, copy of the withdrawal slips. I was unaware that the bank had withdrawn the funds from my account. When on January 31st, 2012, I wrote a check to LACO for $1,058.85 for labor and supplies. The bank refused to honor the check. When I talked to the prosecutor, I was informed that nothing could be done because the bank was located in another county. Exhibit number 7, the non-sufficient from funds case complaint. A hearing was held on the matter that grants a continuance with the judge's advice to me that I contact legal aid. I was referred to the Missouri State Public Defender System, but was not assisted because I was considered to have interest, equity in property, and I was without representation on the felony check charge. And exhibit number 8, State Missouri Public Defender System statements. The court followed the denials of representation by setting a hearing, sending the notice to my old address. The complaint filed June 6, 2012 had the correct address. The warrant issued on August 20th, 2013 had the wrong address. Both were Barron County Court's documents. No address changes and had occurred between the time of the documents. The hearing notice and warning were accountably sent to the wrong address before the notice could reach me. The hearing held undisclosed to me, and on my failure to appear, a warning was issued for me to arrest, also unknown to me. I completed my legal file 1U1 and submitted to the Court of Appeals on August 28, 2013. Then August 30th, 2013, about 10 a.m., I telephoned Consul Rich Carmichael at the appeals court to verify if my legal file was accepted and if approved to serve the bank, and it was. I arrived at the Sheriff's Department about 1 p.m. to have Hometown Bank served, then got arrested. I followed the officer to the jail facility once he appeared from the left and demanded me to follow him. Once we arrived at the jail facility, Officer Bland handed me the warrant for arrest, and he crossed out the M and wrote the F on there. Officer Bland also took my picture, and Officer Hendrick chained me to a table while waiting for the incarceration. Exhibit number 9, the warrant for arrest without bond. At this time, I had still not received a notification of the warrant hearing. When I tried to learn why it was sent to the old address, I could not get an answer, and I was frankly in and out of the courthouse on the non-sufficient fund case and the foreclosure actions. So I was available for service notice there at those times. The clerk was unable to explain why the notifications were misdirect, why they were not serving at those times. Though the warrant for arrest was for a female. The warrant for arrest was for a male, not a female. Exhibit number 10. The officer booked and incarcerated me without bond. When I asked him what no bond mean, I was told that I must stay in jail until the hearing would probably be either the 16th or 17th of September 2013. I was facing nearly 3 weeks of incarceration. The officer's return stated that the officer served the warrant on August 30th, 2013 by arresting me and bringing me before the court on August 30th, 2013. But the bond released without hearing. I was arrested and held until September 6, 2013 without appearance or hearing. I was taken to a cell that smelled strongly of chemicals, and within an hour, I was deadly ill. I was vomiting, had diarrhea with severe fever and headaches. I could not eat, could only drink a little water. I was cold, and I asked for a blanket, but I was informed that I did not deserve another blanket. One night, I became so sick I lost consciousness and feel the inmates call and bang on the doors to try to get help for me, but no one came. When I finally regained consciousness, a woman jailer told me to stop pretending I was sick, that I was in jail, and I was not allowed to see a doctor. Later, I received unverified information that the inmate that tried hardest to get help for me have been punished in the dark room by officers for his efforts.
Okay, right now for the case, wow, so it's a very sad case, but okay, we will continue soon. So okay, so I'm sorry to our listener that so it is a very sad story, and so just hang in there. We would like to let our viewer to know that we are right now so put on pause, and we will continue our case soon. Okay, so and you can see this is the case that we have is we have legal documents on the right hand side of our screen, and we have a lot of document, and we will show to you a little bit later. Okay, so with we will sing. So with this the time, are you okay now? Okay, be strong. Okay, continue. Okay, be strong. Okay, so now our viewer, we will continue the case, and when is she will
first.
Okay, okay then.
Chẳng may là chẳng nên là đọc tới
Well, we will continue the case soon. So we would like to let our viewer to know in advance that she will read the text soon. Okay. Okay, and if you're ready, so we are now on the minute 26 minutes, and so we are like 34 more minutes to go. Okay, go ahead.
Although verified numerous witnesses and documents, none of these were officially recorded by the sheriff's or any of the sheriff's office agents. On Friday, September 6, 2013, I was approached in the exercise yard by a guard who told me that if I paid $2,005, I would be released, exhibit number 11. This officer and I called my friend. He paid the money for $2,005, but the receipt was for $2,000. This non-sufficient found case bond released without hearing on September 6, 2013. I was released and returned home. Exhibit number 12, bond release without hearing. My friend also provided funds for a phone card for me on September 6, 2013, but the phone card was never provided to me. When I asked for a refund, it was denied. After I received release, it took several days for me to begin to recover physically from the incarceration and mentally and emotional shock, and contingent recurring illness continued to cause my grave illness and trauma. And this is exhibit number 13, the phone card receipt that non-refundable. On August 30th, Hometown Bank had filed a bankruptcy. Let me repeat that. On August 30th, Hometown Bank had filed for a fraudulent claim loss for my insurance company that tornado had occurred on February 28, 2012. It was false. There was no tornado and no damage. My birds did not market until March 6, 2012. Exhibit number 14, the February 28, 2012 loss claim. During this period, the bank proceeded with foreclosure. Since I refused to cooperate with the loss claim on February 28, 2012, the notice of trustee sales lapse of insurance as the basic of non-compliance. Exhibit number 15, trustee sales. September 6, 2012. No. September 18, 2012. A policy renewal had been issued from Oak River Insurance Company. The insurance renewal policy is effective from July 6, 2012 to July 6, 2013. Exhibit number 16, insurance renewal policy. On October 10, 2012, Hometown Bank requested the renewal insurance policy effectively from July 6, 2012 to July 6, 2013 from me. A false claim of tornado damage had been filed by the bank on February 28, 2012, and the insurance status at this time was in dispute. The notice of trustee sales list failed to maintain insurance as the basic. However, the renewal had been issued. The illegal withdrawal of the funds caused errors in record. A false insurance claim had been filed, and other irregularities have placed the insurance status in dispute. Exhibit number 17. The first petition of unlawful detainer was filed October 11, 2012. An unrelated case of U.S. Bank National Association versus Carlos Conway was put into Linda Cleartow's file. Mr. Checkett was sworn under the oath that everything he stated were true. But Mr. Checkett was a liar from the beginning. I did not know Mr. Carlos Conway was. My husband, Linda Cleartow, was deceased about 15 months ago. Petition unlawful detainer, exhibit number 18. I filed my response to the petition unlawful detainer on December 4, 2012, noting the bank's numerous irregularities and false statements with verifying documentation, including the illegal withdrawal of funds and the insurance dispute. Exhibit number 19, response petition. A hearing was held on December 13, 2012. a judgment was entered finding the bank was the owner of the described premises located in Cottage, Jasper County, Missouri, by means of having purchased it at foreclosure sale on September 28, 2012. Judgment on December 13, 2012. Although no documentation of such sale or purchase had ever provided to me or in the court's record. At this hearing, no evidence was allowed to be introduced by me. No concern was given to statements in opposition. No consideration was taken of my circumstance or of my exhibits, nor did the court examine the bank's actions in violation of federal law and conduct the unlawful intent and breach of contract. The hearing consists of the judge calling the case, telling me he had already made his ruling and I would receive a copy and to go home. Exhibit number 20th. Consent judgment on December 13, 2012. The insuring order transferred all rights to the property to the bank, added all costs, damages, and requests of the bank against me. There's nothing to indicate that I was allowed to present evidence, nor was there any indication that evidence of any kind was considered. An execution proposition followed. Exhibit number 21, execution. By using Jasper County to confuse me. My property was located in Barron County, Missouri. The judgment was error as there was no evidence present of non-compliance with the contract or failure of payment or any other variable justification for the foreclosure petition and judgment other than insurance, which was known to be in dispute. The judge found the bank to be the owner of the property described premises located in Jasper County, Missouri, and ordered that the bank receive possession of the property along with payment of damages and attorney fees. Noteworthy in its effect and is inexplicable in its inception was that during the period of foreclosure, a court actions against me on February 27, 2013. A notice of bankruptcy was faxed to the clerk of the court for, and by request of the judge, a bankruptcy that was not in my name, had no connection to me. This was placed in my court file and never removed, noted as having no application to the case. It was accompanied by a cryptic note, "Will this work?" This incomprehensible action was never explained. It was shown that the court wrote my case name 12BR-AC00681-01 on then. The bankruptcy notice was sent to both attorneys with a message. Judge asks these to be faxed to you. Bankruptcy page from Weber. Exhibit number 22. Weber's bankruptcy. In addition, my property was described premises located in Cassville, Missouri, Barron County, not Cottage, Jasper County, Missouri. Barron County Circuit Court posted this wrongful bankruptcy case in the Missouri court case net under my name. This reason proclaimed me from locating any representative or any of legal representative. Exhibit number 23, Missouri court case name. The next day, on February 28, 2013. My lawyer, Dale Welly, was helping Hometown Bank's lawyer draft a settlement and compromise agreement against me. Exhibit number 24, settlement and compromise agreement for sign promising not to sue the bank. This bankruptcy was followed immediately request my attorney to withdraw representation on March 12, 2013. Welly's motion to withdraw, exhibit number 25. The court concealed the bankruptcy case that the judge fabricated and put in my file and kept in secret. Never provided this bankruptcy case for me before the hearing on April 16, 2013. When the time came, Judge Head was ruled against me. Exhibit number 26, default judgment, April 16, 2013. On August 16, 2013, Attorney Chris Rivers' response statement of cold-blood Judge Head conduct his evil law to steal my farm, torture me and my family. Exhibit number 27. Rivers' response on August 16, 2013. When I request copy of the transcript, I receive a letter stating this is an associate case. The hearing on December 13 was a consent judgment, and the hearing on April 16 was default judgment. Therefore, the hearings were not recorded, and there is nothing for a transcript. To me, this court had its own correction plan to take advantage of minority for their personal gain, betray their oath, which have been violation the United States Constitution. Exhibit number 28, April 16 judgment. On July 13, 2015, I did a search at the Federal Bankruptcy Court record. It certified that I had never declared bankruptcy. Exhibit number 29, certificate of such bankruptcy. Without technical or procedure knowledge, nevertheless, I appealed the judgment entered on December 13, 2012 for recovery and possession, and the subsequent judgment of unlawful detention entered on April 16, 2013, in the Associate Division of Berry County, Missouri, Cassville. The appeals court was required to examine it with leniency, given the immense deficiency and in consideration of extraordinary effort to pleading represent appealed legal file value 1 and value 2. I made every effort to meet the requirements of the appeals procedure and format, following the outline provided by the court. I admitted and apologized for the deficiency and the request that the court show leniency pursuant to Highness versus Corner and show latitude to me as an unrepresented petitioner. I know that because I'm not a lawyer, I'm a farmer, but I had to do anything in my power to protect my productive poultry farm from the corruptors and conspirators. I tried to call the court's attention to the purpose of the court justice and due process, and that the court is mandated to provide opportunity for correction of these failings where otherwise the petitioner has a valid complaint. I noted that I was aware that the court is forbidden to dismiss a valid complaint based on technical or similar inadequacy unless it is established that the claimant has absolutely no possibility of supporting and providing a claim. The appeals court apparently gave no consideration either to these pleadings or to the circumstance and lack of resource of my status. The court dismissals in order to protect Circuit Court of Barron County's evil law, and basis for doing so was technical failings and for judicial economic impartiality and fairness during this extended period of time. My health, my family, my financial, emotional, and living deteriorated. Exhibit number 30. Appeals court dismissed my case. I think we stop a little bit. This is a long and evolved case of determined abuses, concentrated prosecution, intentional evil inflict on an innocent and trusty refugee family. The deprivative of these abuses and the unfathomable injuries inflicted on me and my family, it's even more than staggering when it viewed. I am among refugees, retains and maintains such formidable courage in the face of the abuse and torment here at that distinguishes the American code science. What makes it harder to understand is how this tiny refugee farmer widow has branched the fires of corrupt courts, bureaucracy, crook business, and extreme prejudice to maintain that trust in my adopted country. But it does help explain why the history, the culture that has shaped me. I was determined to do all I can to help similar victims and fight for the freedom and protection of those brave people in the past and promised but denied. And also to this court, I have ultimately come with little and determination and courage to see if the high words, laws, oaths, any tie true meaning in this country, and especially to this broadcast. This is where the formidable Hmong refugee widow as me stands. There's a little need for me to try to present a convincing argument. The facts speak for themselves. They are fully presented, documented, and inarguable. The law leaves no question that the actions were unlawful, that they violated constitutional law, federal law, state law, fiduciary law, moral law, commercial law, and court procedure law. The injuries are irreparable, grievous, unjust, extreme, intentional, and defensible. I am entitled to redress and has requested redress and remedy. Those who have violated the rights, broken the laws, act in contempt, and with complete indifferences, betray every principle upon which this country was founded, deserve sanctions of the strongest of kind. A proceeding needs to be set up in which every person, every court, from the lowest to the highest, can base, believe, and use as guide, a warning. The great target of my case is that here in America, where such rights as were we so inconceivable, violated, or taken for granted, a courageous refugee has almost single-handedly taken on the strongest powers of my adopted country, right a grave injustice. I fight not only for myself, but for every person in America, natural or alien, who still believes in justice and freedom in this country. I have fought through gauntlet and have come here to bring my case to the place where I believe justice surely resides. I had placed in your hands. I need your help and your expertise to rescue me and my family. I did not do anything wrong. Judge had ordered the unrelated bankruptcy case put in my court file, ruled against me. The federal bankruptcy certified that I had never declared bankruptcy. Exhibit number 30th. Judge Head is a crook. He cheated on me. Both judgments on December 13, 2012 hearing and April 16, 2013 hearings were not recorded. Exhibit number 28, no record. The appeals court dismissed my case to protect the Berry County Circuit Court's injustice law and corruption activities. Exhibit number 29. I'm sorry, exhibit number 30th. Thank you.
Okay, continue the case.
No, we're done.
You are done?
Yeah, done. Okay. No, có hai lưu nhiều kia không?
하죠.
This is to the public viewer. I did not mean to harm anybody or point to anybody. This is a true case, and I thank you for listening and watching. Especially, I'd like to thank you for the iFreedom TV like to interest on my true story. That's what happening to me and my family.
Thank you.
Thank you.